Yes.
Adjournment request, if any, from item number 1 to 7.
Yeah, please, your lordship.
Yes.
Lordship, I beg to mention item numbers 4 and 5, my lord, of today's list. My lord, I'm
5?
seeking my lord, I'm seeking a short adjournment for 1 week, my lord, with all respect, my lord.
These are review matters, no?
Review matters, my lord. I'm seeking a short adjournment for only 1 week, my lord.
As prayed for. Have you informed the other side?
My lord, yes, my lord.
Have you informed the other
Yes,
side?
yes, my lord.
As prayed for, on behalf of the review petitioners, re-notify. When do you want it?
My lord, can it be on 28th, my lord?
Okay. The date will be given by the court master
My lord,
after seeing the
my lord,
calendar.
my lord.
But give it to it.
Yes, Lord.
All right.
I'm so obliged, my lord.
Yes, please, your lordships. Lordship, I beg to mention item number 1. Similar matter has been pending before the Supreme Court, your lordship. Let the matter be fixed after puja vacation.
As prayed for on behalf of the petitioner, re-notify on give a date after.
15 October.
Obliged.
Adjournment request from item number 8 to 15.
May it please your lordship, in item 14, my lord, we obtained the consent of the other side. However, my lord, in the connected items in 13 and 15, my lord, the respondents were not willing to give their consent. But my lord, there is an unforeseen difficulty, which is why additional AG, my lord,
Who appears in items number 13 and 15?
my lord, in 13 we have senior counsel DP Choliha.
Senior counsel is appearing.
Now,
Yes.
can you mention after when the case is called out?
My lord.
Let's see. Let them be present here.
Fine.
We will see what is to be done.
May I please your lordship? Your lordship, I beg to mention item number 12.
Yes,
We have taken consent from the other side. Advocate DN Sharma is having some difficulties today.
that's true. But then we have less matters today because of the temporary bench. Now, if you take adjournment in all cases, what do we do? Doesn't look nice to retire to the chambers.
Your lordship is having some difficulties today.
Who is having difficulty?
Advocate DN Sharma, your lordship. He was supposed to argue this matter.
Have you informed the other side
Yes, your lordship.
on the ground of difficulty of the arguing counsel, namely Mr. D.N. Sharma? A prayer for adjournment has been made. Let this matter come up for consideration. Give a date anytime.
1710.
Yes, your lordship.
Any other request?
Please, your lordship, I beg to mention item number 16 of the supplementary list, your lordship. With the consent of the others of your lordship. Finally, adjourn the matter for the day, your lordship.
For the day.
Yes, your lordship.
All right, pass over for the day.
Obliged.
All right.
Look, I have a prayer for listing of a writ appeal. I have a prayer for listing of a writ appeal. The state has preferred a writ appeal. I prefer, if possible, taking up on Tuesday, on 26th.
What is the urgency?
The
Otherwise, also writ appeals have to be listed straight away. But then, why not in its usual course?
some urgency I'm expressing this before the single bench, the matter is fixed on 27th. The other matter, similar.
Have you challenged some interim order?
No.
Then?
We have challenged the final order, but subsequently another petition is in filed before the single bench. That is fixed on 27th.
All right. All right.
All right.
Daily list for orders item 2.
May it please your lordship. This is a matter relating to conservation of Deepor Beel, which is an international Ramsar site.
Yes.
And we had several prayers, and the court is monitoring the case. On the last occasion on 4/2/2005, the division bench ordered that the construction activities near landfill and all, those should be cleared by the PWD. The PWD was supposed to give their affidavit.
Is that the only concern today?
Well, it has come up for orders. And there is another order of the Supreme Court. Supreme Court is monitoring the entire wetland because the climate change has taken place, and in 2050, there'll be crisis.
I think the primary concern of the petitioner is with respect to double tracking.
Not only
Is it-
double
is it-
trapping, and also the wildlife conservation, the wildlife management.
That's right.
because-
So the primary concern is removal of dumping sites,
And construction activities around the.
construction activities
Yes.
and railway tracking.
And the declaration of eco-sensitive zone, because the central notification of 2017 wetland covers all, it's in the concurrent list. And forest being in the
Yeah,
concurrent list, this, and the High Court has, the government is taking a favorable stand. They are also in favor of conservation.
Mr. Saikia?
Yes, Lordship, this is not an adversarial litigation for us.
Yes.
So eco-sensitive zones draft notification has been issued by the central government on 2nd of July. 60 days time has been given for public objection or whatever. So it is in process now, Lordship. This draft notification, I would like to place it in the form of an affidavit, number one. Regarding the other part, that removal of the area, sand filling for PWD is concerned, that has been stopped and it has been removed, and affidavit to that effect has already been filed. But I have some reservation whether all the sand has been removed or not. Although affidavit says they have cleared it,
No.
but I have some doubt. So I will
Mr.
personally go and visit the,
Mr. Saikia, you please
I'll personally go and visit it.
take
Lord.
some personal interest in the matter.
Lordship, yes,
You know, the difficulty here is this. Now, these are all Ramsar sites.
Lordship.
You know why it is called Ramsar?
Yeah, I know, Lordship.
Because this was a conclave sometimes in
Yes.
1971
Yes, Lordship.
in the city of Iran,
Lord,
known as Ramsar.
Lordship.
And the government is very, very, conscious about it because the ISRO photographs, I have had the occasion to handle this matter in different high court.
Lord,
The ISRO report says that the area under wetland has increased manifold. And therefore, seeing this, there were 12 wetlands which were identified. One in the state of, in state of Mizoram that has been notified.
Loktak.
No.
Loktak is in Manipur, there is another one.
Manipur, there was already existing. It was identified from before. One is Pala wetlands in Mizoram. So the Mizoram High Court is in CC know the matter.
No.
Pursuant to the directions issued by the Supreme Court, where a PIL, suo motu PIL had to be
Registered.
initiated in all the high courts, wherever, in whichever state this was identified.
Lordship.
So I believe that since this matter is pending, we need not have anything here. This PIL
Lordship.
would do, but Mizoram, we would like to know the status of Mizoram. Can you just liaise with the Advocate General?
Yes, I'll speak to him and I'll speak to
And
him and I'll
an
come.
affidavit to that extent, because see, Deepor Beel would be the largest wetland of Asia, as I understand.
Lordship.
So what to do now?
Your Lordship's leave, one
And who
submission.
pays for the railways? Have the railways been made party?
Yes, they have been.
They are a party, Lordship, they are a party.
Who appear, you appear for Union of India? No, but what is the status? I mean, are you double tracking from Kamakya to Azar? No, but that's very important. This is done urgently for the reason that double tracking, if at all it is necessary, you will have to change the alignment. But double tracking, how can you change the alignment? It has to be parallel to the track which is already set up. And how would you save these golden langurs? How would you save these elephants? It's a big animal corridor. also.
Big elephant.
Golden langur is in the western part of Assam.
Here it is the elephant.
Elephants. And it's a bird sanctuary. And the most important part is that the Supreme Court had directed the registry of the Guwahati High Court. Guwahati High Court is included in the Anand Arya's case to register the PIL. My case was prior in time than the Honorable Supreme Court's direction. So Your Lordship has rightly said, let this case be here. And there is an order to the effect on 4/3/2025, where the registry of the High Court of the division bench.
You catalog this file properly, not this way. Huh? We can't handle a file like this. Give me the judgment of the Supreme Court.
But the Anand Arya's judgment is on record, Lordship. The last order of the Honorable Division Bench was on 4/3/2025.
You have heard the learned advocates and the learned advocate general or the parties. This PIL has been filed seeking the intervention of this court for the purposes of safeguarding the flora and fauna of the Deepor Beel and Rani Forest Reserve by prohibiting activities like continuance of dumping sites near the wetland, laying of double track which would cross through the animal corridor, and other construction activities. It need not be reiterated that Deepor Beel has been identified to be one of the largest wetlands of Asia, which is very rich in flocking of migratory birds. This was declared a wetland. This was declared a 17th wetland by the decision of the government sometimes in 1989. It was also declared to be a Ramsar site in accordance with Ramsar Convention. It was brought to the notice of this court by way of this PIL that the whole flora and fauna of the area is being spoilt by garbage dumping, soil digging, encroachment, which are definitely to the peril of the pristine fresh water bodies. The Rani Reserve Forest provides for an elephant corridor. There are certain obligations which are to be followed by all, including the government. Which have been identified in the Ramsar Convention of 1971. Those obligations are also in consonance with the provisions contained in Articles 21, 48A, and 51C of the Constitution of India. There cannot be any doubt that these wetlands are the vital ecological assets, and the preservation of these would be helpful for controlling floods, for recharging the groundwater, and for conservation of biodiversity. The learned advocate general was very forthright in submitting before this court that this is no adversarial litigation. In fact, we would like to point out here that the Supreme Court has also taken note of this concern in WPC number 304 of 2018, in which it was noticed that several hectares of wetland have increased, which information is derived from the latest ISRO photographs. The state of Assam also, we have a wetland authority here, no?
The
State of
forest
Assam?
will be knowing better. The respondents.
It has been established, the rules are in the process of framing. Yes, it
The
is.
establishment is there.
Yes, sir.
The state of Assam has a wetland authority, but the rules governing the same are in the process of being formulated. Some wetlands were identified and by the direction of the High Court, by the direction of the Supreme Court, the High Courts were asked to institute suo motu PIL on the report of the scientists who had furnished their report. It appears that on account of such a direction, a PIL has been registered in the High Court of Mizoram. Since the present PIL concerns the same issues, the directions of the Supreme Court in WPC number 304 of 2018 referred to above would be monitored in this petition only. The learned Advocate General has further informed this court that most of the dumping sites have been removed from the area of the wetland,
Completely we have removed.
for which necessary affidavit shall be filed. Necessary updated affidavit shall be filed
Lodge.
by the next date. We would also require we would also require the updated fact check with respect to prohibition on reclamation, setting up of new industries, the ban on manufacturing, and efforts at preventing the discharge of untreated waste harvesting and control of motorized boats in such water bodies. The State Forest Department also would be required to inform this court whether any comprehensive plan for wildlife management has been drawn up and is being practiced. Stop. What is this name? Mr. R.K.D. Chaudhary. Then. You're appearing. Just read out the talk. It is not cataloged properly. It will be very difficult for me to come to that page. Just read that paragraph. But this is part of the order passed by NGT. No. We are not interested in that.
That is respectively that include the perspective to provide permanent mitigation measures for
No. This doesn't satisfy.
Our concern is only with the elephant corridor. Because that means
Your concern is with the elephant corridor, but our concern is for the wetland as well. So therefore, we would like you to file, and this was an affidavit before the NGT.
no.
But you're reading from some order of NGT, no?
NGT order
We would like to have the affidavit of the railways, updated affidavit of the railways, that if you're at all contemplating of double tracking it, whether you have changed the alignment, whether you have taken care of not disturbing the animal corridor. Forget about that. We need an updated report, a fresh report, along with the report of the PWD. Right? So whose name should I write here? Can I have your name, please? Mr. B. Chakravarti, learned counsel for the railways, submits that on the next date, an updated affidavit shall be filed with respect to the decision regarding double tracking of the railway line, which does not obstruct the elephant corridor in any manner whatsoever. The double tracking has also to be in consonance with the obligations under the Ramsar Convention, as that would also be a concern of this court in the present public interest litigation. Stop. Let this matter come up for consideration on. We give a month's time,
Your Lordship,
and by that time, all fresh affidavit.
Lordship,
we
I'll update the status now.
come up for consideration after immediately after puja holiday. By that time, the affidavits as referred to above ought to be filed in the registry.
1710.
Deeply obliged.
Explain my arms.
After?
Just to keep around 17. And 1 second, just a minute, Mr. Advocate General, one thing more, I just forgot, Lordship. I forgot about the ground troughing. Ground troughing. That's a concept which is very necessary for these wetlands. You know, these are ISRO photographs.
Lordship.
Ground troughing is a term which has been coined by these scientists, where people of all discipline, they go to the site and then they see what is the actual thing on the ground. I don't know why it is called ground troughing, but that is one of the important steps.
How that second part is spelled, Lordship?
PROTH.
Plotting.
Troughing.
It's
Ground
coming
troughing.
from the book trotting.
No, not that's not troughing. It's ground truthing or troughing.
Oh.
Well, I'll check up, but please find
Yes.
out whether it has been done or not. This is the second step. One is identification by the photograph and all
Lord.
that, then ground troughing.
Lordship.
That is necessary. And in the process, you find out that there are some other wetlands also. Because the area is increasing surprisingly everywhere.
Here it is
decreasing.
during the summer rainy season, the wetland becomes much broader.
Yes.
And during the winter, it is lessened.
That's right. But then there are nine objective criteria
Lord.
on which a wetland is determined.
And for the purpose of maintaining the water level, Lordship, we have connected it to the Brahmaputra, Lordship. During the winter also, there should be proper storage of water.
So give all this in your affidavit.
Yes, Lord.
So that
We'll do
we write it.
We are trying our best to restore it, but there are some hurdles, but with Lordship's interference, that will be cleared, Lord. Deeply obliged, Lord.
Item number 3.
Your Lordship. Well, this matter relates to management or rather mismanagement of Hayagriv Madhava Temple.
We had heard this matter earlier, no?
And
You agree? We had heard this matter earlier.
But before my learned friend start, my lord, there was a direction to take, file an affidavit.
Yes.
My lord, I could not file the affidavit because I have not received a detailed instruction, but I have received the written instruction that the temple is come under the ambit of the 1949 Act. my lord. Since my lord,
1959 Act.
59 Act. As the temple received the annuity from the government.
It's receiving annuities from the
From
government.
the government. So
Ah,
for
so-
land.
So therefore, can you sort of can you go back to that earlier decision? No. It has to be under this act.
Right.
And therefore, there has to be a constitution of the Committee of Management.
Yes.
So that has not yet been done
No.
on the sole ground that there was a.
That is the only ground, but if Lordship will clarify, that can be done.
Please, Mr. D.
let the affidavit come, my lord. Let the
Mr. D.K. Sharma. Yes, by order dated 28/7/2025, this court had directed the respondent to file an affidavit bringing on record the fact whether the land appertaining to the temple in question is owned by the temple or has been allotted to it by the government under any scheme. Or perhaps the temple has been allowed to retain 37 acres of land, which originally existed and was owned by the temple management. There has not yet been any constitution of the committee for management of the annuities of the temple as mandated under section 25A of the Religious or Charitable Institutions of Public Nature Act 1959. The sole ground for not constituting such committee for management of the annuities is a decision by a competent court, a decision by a trial court in a civil suit constituting a committee for management. Whether such committee would stand superseded by another committee which is required to be constituted under the Act of 1959 is also the question which has been posed to the learned counsel for the respondent. Mr. Sharma, learned additional senior government advocate Assam, submits that he has received only part instructions, but he shall be filing the required affidavit by the next date. Re-notify 3 weeks. All of you. Yes, please do.
In this matter, Lordship, I am for reference number 2, Lordship. Name of the SCT may be reflected in the cause list, Lordship.
Give your slips, it will be reflected.
No, Lordship. In cause list, Lordship, it has not been reflected, Lordship.
The names of the parties ought to be reflected in the cause list henceforth.
All right.
The
22nd
names
chapter.
of the learned advocates for the parties ought to be reflected in the cause list henceforth.
Item number 6.
May it please, Your Lordship. Lordship, may I kindly peruse the last order, Your Lordship.
Last order.
Yes, Your Lordship. Your Lordship, direction was given to file their response, Your Lordship. However, it has not been filed yet, Your Lordship.
Yes, who appears?
Your Lordship, the name of.
Mr. Khataniar.
Yes, yeah.
Is he here? Will be required to decide it urgently. Look here. Despite direction of this court dated 8/4/2025. No affidavit on behalf of the respondent has been filed. There is no appearance on behalf of the respondent. Leave that. Has not been filed. Let such an affidavit be filed positively by the next date. Re-notify 3 weeks. Inform Mr. Khataniar. We have not marked his absence. Tell him we have not marked his absence.
24th September.
Deeply obliged.
Item number 7.
Coming for the first time.
Well, it had come earlier, but because of the filing of the affidavit, matter was adjourned.
The pleadings are complete. There's a delay in the review that they have filed. I'm objecting to the same. So the pleadings are complete. It's right for hearing with regard to the delay matters.
For the reasons stated in the application seeking condonation or delay of how many days?
It's 203 days, man.
203 days.
I'm opposing that, man.
That's all right.
Yes.
Let's just click here. After hearing the learned counsel for the parties, we find that good reasons have been assigned.
Malad, may I be permitted
Doesn't
to?
matter. You argue it on
Malad,
merit.
there's a delay. Malad, what has happened is the order by this honorable court was for them to go before.
Where is the limitation for filing review?
It was 30 days was there, my lords, for them. My lords, we kindly see, they went and appeared before the MSME council. The direction by the division bench on this court on,
Why do you want to contest a petition with the hands of the petitioner tied behind his back?
my lords, time and again, I have got about 8 authorities, my lords, 5 from the Supreme Court, 4 by this
That's
honorable
why
court.
We will give you an early date.
My lords,
Did you
we
register?
kindly look at the conduct of the parties over here, my lords.
That's all
I
right.
am a sole contractor. They are a big corporate. They are the state, the mighty state, my lords. I am out of pocket by 11 crore rupees almost 10 years back. I went in the writ petition. I succeeded in the writ petition. They came in writ appeal over here. The writ appeal was partially allowed with the parties being relegated to the MSME council because I am an MSME enterprise. What thereafter happens is that we go before the MSME and we appear before the MSME on 9th of November. 85
IA
days
number.
were lapsed.
That's all right, we have heard. IA number.
Miles, may I be permitted to cite judgments also with regard to this? Even my lord's judgments, my lords, are there, my lords, with regard to the fact that delay such as this, the Damocles sword is not to be kept hanging over the parties. We have gone and appeared before the MSME. I've given my provision over there. I succeeded over before the single judge.
You're
They
only
came in
delaying
appeal.
the matter. We will hear the review. Is this review? No, appeal.
It's a review petition, my lords.
Review. So review, you know the limit, you know the strict jurisdiction of review. Let it be decided. We'll deal with it. Strictly in
My
accordance with
lords,
the order.
then, my lords, may I request for one thing, my lords? My lords, I will file a short reply to the review petition. My lords, we keep this application also pending for all, my lords, we kindly look at it.
Alright.
My lords, we find that the
Does
review,
it make any difference? Because as it is, we'll first.
I might be able to persuade your
Just a minute,
lordships.
with us allowing this petition and fixing a date for review, would it cause any inconvenience to you?
Was 203 days delay when they've slept over it, my lords.
Mr. Counsel, you have
In
heard
this
the views of
digital
the-
age, my lords,
What is the purpose of repeating your argument when you know that it is not cutting any
But-
ice up till now? We have heard you.
but
We will only give you an early date. Let us hear the review. Or if you're ready on the review, we can hear it tomorrow.
Pulse can have it on the 27th of August. We'll argue it out on 27th.
Here. Let this. But without allowing this, it will not be registered.
Well, I am not conceding. I am opposing it. I am in your lordship's
That's
hands.
what we were doing. You're forestalling the court from passing an order.
If my lords will just consider looking at their affidavit.
See, review otherwise also they'll
I understand, my lords. The reviews, the contours are very narrow.
You're being, that's a blinkered approach, Mr. Counsel.
No, not at all, my lords. I just felt that 203 days delay should not be condoned when the state was very well aware of their rights, my lords.
That's right. We have said that, we have taken it into account, we have
Please, ma'am.
considered it, we are allowing it.
Okay.
Now let's see what is there in review.
Please, my lords, may I have it on 27th of August. ma'am.
Yes.
No, look, can it be on 4th of September, my lord, if not inconvenient to the court and the other side? my lord?
A week later, Mr. Paul,
My
No,
lords,
Mr.
just-
Paul.
Yes, my lords, I'm Mohit Paul. My lords, just 1 minute, my lords, I apologize. Just see that.
Don't be disheartened by this. We always condone the delay unless it is. for
Not
1.5
necessarily. I have an order of your lordships and your lordships was the
We
acting
have-
chief justice. 128 days delay was not condoned, my lords.
For a reason.
My lords, I can assure your lordship there are reasons in this matter also.
You reserve your energies for contesting the review petition. Argue on order 47 rule 1.
My lords, can it
I'm
be?
sure they will not be able to overcome that. Anyway, you
My lords, can it be 10th of September, my lords?
10th of September,
Lordship,
Mr. Saikia,
Lordship.
okay?
Lordship.
Take it. We have heard Sri PJ Saikia, and senior advocate for the applicant / petitioner, and Mr. M. Paul, learned advocate for the respondent. There is a delay of 203 days. Mr. Paul, learned advocate, has contested the application vehemently and has submitted that the delay of 203 days in preferring the review petition has not been explained. In fact, the state was aware and has not been explained. But however, looking at the application and after hearing the parties, we are of the considered view that the delay in preferring the review ought to be condoned. We order accordingly. The application stands allowed. the registry will process the review petition number 4761 of 2025. First up, the review petition shall be listed before this court on
May I have it on 10th of September?
on 10th of September.
In the meantime, in case I wish to file a short reply to the review, my lord, so I may be permitted.
You don't require the permission of the court. You file a reply.
But that time, registry will not. Registry will not.
You file it across the board, we'll accept it.
I'm so.
We do not go by all these,
I understand.
procedural formalities unless it is
Absolutely.
required.
Absolutely, your lord.
Yes.
Deeply obliged, my lord.
Item number 8.
Lordship, in this matter, pursuant to the last order, Lordship, I have taken steps. However, the service report has not come back. Lordship, this matter may be after 2 weeks, or if your Lordship will permit, I'll take steps once again.
Second pension, no. The matter is pending before Supreme Court.
Yes.
So
Yes.
therefore,
what that-
otherwise also this requires to be adjourned. Let's see what the Supreme Court says.
Yes, Lordship.
It is anomalous otherwise.
Yes.
15 years of qualifying service, then 15 years or 10 years, what is it?
10 years.
10 years.
Yes.
10 years. And then it is left, I mean, it's absolutely unchannelized, the power to
Yes.
condone.
It's
One. And two, second pension, why?
Lordship.
Let's see, the question is
Lordship.
there before the Supreme Court. Dana. Awaiting the appearance of the respondents in the matter. The case is adjourned to, we give you 4 weeks. Let us see the Supreme Court judgment
Let it be after the vacation, Lordship.
after puja holiday. You call it vacation or holiday? There is essential difference.
For us.
You know the difference between between group of holidays, set of holidays and vacation.
For me, Lordship, vacation would be something like where we would go out.
Administratively, when the court goes on vacation, there has to be a vacation bench. Holidays, there is no need. There can be a lock on the High Court gate.
Normally, there are 1 or 2 vacation.
All right. Puja holidays, don't write puja holidays, give a date.
2014.
Lordship.
Item number 9.
Mayor Pujo.
Yes.
Plus, if the appellants are before Lordship with limited grounds against the order of the Ranets there. Let's say we are aggrieved by the decision of a government Lordship, whereby Lordship, we are not saying that we are not entitled for pension because we are the employees working in a minority
Let us see the
development
appeal
board.
judgment.
A Lordship will find that judgment page 79. The contention of
Can
the
you give us 2 minutes?
Lordship.
But you are being paid from the grants in aid. Especially when the posts were retained.
Yes, that is the stand of the government Lordship.
And that's true, but do you dispute it?
Yes, Lordship, because since my stand is that Lordship, since we have been appointed against sanctioned posts with the concurrence of the finance department, number one. Second ground is, Lordship, the post has been permanently retained by the government. Lordship, may kindly for a moment see page 63.
The stand of the state is absolutely similar, that your post has been retained. It was a sanctioned post, but sanctioned post in a different sense, sanctioned for the purposes of running the board. And whether board would be state, even if there is instrumentality of the state, there is a state presence, it is a state. But for the purposes of hoisting on such board, the financial burden, there has to be something more than that, right? So I don't think you would be entitled.
Lordship, third ground is that, Lordship, the rule 31 of the rules 1969, it lays down, Lordship, the three
These are
conditions.
pension rules.
Yes, Lordship, that we have fulfilled. Lordship, for a moment, kindly come to page number 63.
63.
63, Lordship. This was the, yes. No, not 63, 54. I'm sorry, Lordship. 54.
54.
54, Lordship. So these are the post Lordship sanction. And the Lordship say bottom sanction has been issued with the contents of the finance department. Then page 65. And furthermore, Lordship, I want
For a limited period from 28 up to 28 to 1987. And then what happened? After 28 to 87? Was there a further extension?
Lordship, we have been engaged there, Lordship. There are
No, I'm asking you something else. If you don't have an answer, say no. Just don't dodge it. It says that the post is created for a period up to 28 to 1987.
Lordship.
Permanent retention.
Sanction?
Then page 58.
No. Okay, where is permanent sanction? Permanent retention. This is retention, not sanction. The retention is permanent. It's the government statement. It is retained permanently. Sanction for a period for the grants in a salary. Then they'll be entitled to pension. Let's see pension rules, 1969.
State, what's up, page 23, Lordship. The first three conditions of qualifying service.
Page 23 of.
Page 23 of the Assam Service Pension. Conditions of qualifying service.
Yes.
Merit, Lordship.
Yes.
The service of an officer does not qualify for pension unless it conforms to the following three conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Thirdly, the service must be paid by government. Now, my respectful submission is that, Lordship, we have fulfilled all these three conditions.
There is serious doubt, no? Permanently retained and permanent post are two different things. Sanction also is for a particular period. And then you're not being paid by the government as a government employee. You're being paid as an employee of the board by grant in aid. How do you fall in this category? Tell us. You would have been more than willing to give you pension, but for the rules.
Now, Lordship, one more submission, Lordship. Lordship, kindly come to page 89. In a similarly situated ground, Lordship, this service has been incorporated under the new pension code. Page 89. This is one of the instances we have given, Lordship.
Page 89.
Page 89, Lordship. This order issued 15th of February 2024. Here also, this employee is under the Minority Development Board, but his service condition is treated under the new pension rules. So we are also seeking.
Just a minute. No, this is annexure 4 that you're referring to, no?
Yes, page 89.
Page 89, what does it say?
Lordship, the employee has been appointed, Lordship, under the Assam Minorities Development Board. We are also similarly situated, but his service is, Lordship, treated under the new pension rule. Lordship, kindly see
The appointee will not be governed by the existing Assam Service Pension Rules 1969
and order.
and orders issued thereunder from time to
He will
time.
be governed by new set of pension rules under the new defined contribution pension scheme
So,
after 2005. So we are also asking for, Lordship, similar relief.
no, contributory pension you would be getting, no? You would be getting contributory pension. They have retired. This is pursuant to, this is 15th of February 2024. You retired long time before. This was not the terms of your appointment.
No, two of the
What's the post-retiral thing that you're getting?
post Lordship, one is driver.
This will not give you any succor.
Out of 6, Lordship, 3 have already been retired. And they have been serving as a grade 4 and grade 3 employee, Lordship. Peon and LDA, Lordship. In page 2 of the. So since, Lordship, we are also, Lordship, discharging the same function, Lordship, as the other government employees. So we, Lordship, we are also entitled and discharging the same public function. Some benefit, Lordship, because since 1986, 87, we are rendering our service without any benefit.
That's true, but those sentiments is not.
Grade 3 and grade 4, grade 3 and grade 4.
Those sentiments do not work out for the government.
I understand, Lordship, because it is the autonomous body, Lordship. They are not falls under the definition of this. But some benefit, Lordship. If government thinks that they can do something, at least they can happily retire, Lordship.
I wish I could be there. Where is the appearance here? Which missed out. Sumitra. Yes. You are Sumitra Sharma.
Plus MD Bora.
MD board. Oh. We have heard Sri Deka, learned advocate for the appellant. And MSMD Bora for the respondent state. The appellants are the employees, bracket grade 3 and grade 4, working under the Assam Minorities Development Board. They have challenged the judgment of the learned single judge passed in WPC number 5747 of 2013, whereby their claim for being paid pension has been rejected. The contention on behalf of the appellant is that the learned single judge did not appreciate that they had been serving the board for a long time on posts which was sanctioned by the state government. And such posts were permanently retained. Thus, they qualified for being paid pension under Rule 31 of the Assam Pension Rules 1969. The stand of the state, which was accepted by the learned single judge, was that even though the posts were permanently retained, but the sanction was only for a limited period. The appellants were paid out of grants in aid rather than from regular government salary budget, which comes under ordinary head The other contention of the state, which was accepted by the learned single judge, was that notwithstanding the fact that Assam Minorities Development Board has state presence and also possesses certain trappings of the state, bringing it within the ambit of Article 12 of the Constitution. But there would be a distinction between a body which is taken to be a state within the meaning of Article 12 of the Constitution and a body / board which would be foisted with financial burden. The learned single judge relied on a judgment of the Supreme Court in State of Assam versus Barak Upatyaka, DU Karmchari Sanstha, 2009, 5 SCC 694, to hold that even if a body is treated to be a state, a board or a cooperative society would not be considered as state government, and the employees of such a body would not be called the holders of civil posts or employees of the state government. Thus, even though the board in question may come within the definition of state for other purposes, but the employees of the board who were being paid their salary from grants in aid would not be called government servants. Rule 31 of Assam Service Pension Rules 1969 is very categorical in spelling out the conditions of qualifying service for pension. The services of an officer would not qualify for pension unless it conforms to three conditions, namely that the service must be under the government. Secondly, the employment must be substantive and permanent. And thirdly, the service must be paid by the government. There is a caveat by way of proviso, which declares that if the governor may, even though either or both of the conditions 1 and 2 are not fulfilled, could declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. And in individual cases and subject to such conditions as the governor may think fit to impose in each case, allows service rendered by an officer to count for pension. As already has been noted by the learned single judge, the appellants are the employees of the board, which is employees of the board, and they served on conditionally sanctioned post, which posts were permanently retained and were being paid their salary from grants in aid and not from the ordinary head of the government for disbursal of salaries of the government employees. The Land Council for the appellant drew the attention of this court Two, a notification of 2024 with respect to one of the employees of the board who was allowed
benefit under new pension scheme. Last line.
to be governed by new set of pension rules under the new defined contribution pension scheme. This was a specific declaration with respect to the employee in question and would not entitle the appellants to contend that they are being treated differently. For the reasons aforestated, we do not find any reason to interfere with the judgment of the led single judge. The appeal is thus dismissed.
I'm so deeply obliged, Lordship.
Item number 10.
Yes,
Milord, this is an appeal against the order of the London Honorable Single Bench. Milord,
when you refer to the single bench, it's the common parlance is learned. Don't get confused, learned and honorable, both. It's all respectable.
Milord,
All
I
these
got
questions
incorrect.
are acceptable
Milord,
and
Milord.
respectable too.
Milord, kindly refer to this annexure 2, Milord.
Now, what has happened? Tell us.
Milord, my client was appointed as as associate professor in the NIT Silchar, Milord, in the year 2010. Milord, thereafter in 2015, after having been confirmed in his service, he was asked by a letter that while applying for the job, it has been found that your experience was short.
For what?
Experience actually.
Experience short for what consideration? For further promotion?
No, not for promotion, even for appointment.
Okay.
Okay, they did not raise questions or issue notice to the people who appointed him. He was asked to say the why your service shall not be terminated, Milord. Milord, this has not been annexed.
How can you use these documents when this was not before?
Milord, actually, we have come. It has been appended in the main petition, Milord. And this is.
Has it been considered by the single judge?
No, Milord.
Basically challenging the interim order. Interim order he is challenging, not the main case.
We have prayed for this pending this writ petition.
The interim order which is challenged.
Milord, we have challenged. We have made a prayer to stay the ongoing recruitment process from the post of associate professor to the HAG. HAG means higher academic grade pay.
What has happened to your main writ petition?
It is roaming from this bench to that bench for 1 year.
Pending consideration. Don't say all this. You can say pending consideration.
Milord, for 1 year it is.
From this,
Milord, sorry, Milord.
Files do not have feeds. They get transferred to different benches. I mean, you have to show some respect to the High Court.
Milord.
We should respect to the lawyers. You should respect to us.
With great grief, Milord, for 1 year, I'm not being able to even admit this case.
Lordship, what my learned friend is saying is not actually correct. Fact is that on the last.
To speak.
Yes, Lordship.
Milord, it is only 2 days. If 2 days after 2 days, it will be 1 year full. And Milord, we have not been able to, for the time being.
Therefore, you filed a writ petition before the learned single judge, challenging what?
Challenging, Milord, in the meanwhile, while my client's right was infringed once, and we made in the writ petition, we made a prayer not to hold any other recruitment process pending the writ petition, Milord. Thereafter, even in 24, they issued a notification for recruitment, which I challenged and I wrote to the Minister of Higher Education. And after that, it was stopped. Again in 25, Milord, they have asked for applications for recruitment.
And do you qualify for applying?
Milord, no, I do not qualify because of an order in their minutes. They said, since you had shortage of experience, and such shortage, I don't know how, will be made up in your application to the next promotion.
And your lordship will be appalled to see, they have written in the minutes, if Professor Day, means the applicant over here, Professor Day applies elsewhere, this institute will write this information to the prospective employer.
Are we happy being called upon to decide that?
No, my lord, I'm saying the people who question his appointment are not expected to give him promotion. In 2015, there was a notice. I joined in 10, my lord, I received the link, my lord. Well, I made a prayer for stay and it has been rejected, which is why I've come over here.
The writ records. Writ records.
We don't have.
You don't have that. With appeal, you don't place the writ records.
Interim order.
When a second copy, you don't bring it. No, this is the procedure elsewhere. How do we know which documents has he annexed? What has he prayed for? Under what circumstances he has asked for interim relief? नहीं होता है, but we are just asking. No, we are prima facie, we are not inclined to interfere with the interim order. Rejection of the interim stay. But then for the purposes, because appeal is a continuation of the writ proceeding, we would also like to see what was your prayer. If your prayer is honest, we'll dismiss the writ petition also here, subject to the approval of the both sides. Why do we keep? You have Mr.
Roy, Nitpendra Roy.
Mr. Roy, your objection is that your writ petition kept on being transferred from one court to another.
My lord.
And then in the meantime, you filed an interim application.
For a stay on the recruitment.
Interlocutory application for a stay of the entire process.
Without participating in the selection process.
Without participating in the selection.
My lord, my
Just a minute.
My application is being rejected twice.
Can you allow the court to complete the sentence? Now, in order to completely satisfy you, we will hear this appeal as also the writ petition subject to your approval.
My lord.
And we can do that. The appellate court has the jurisdiction. And we'll otherwise either allow the appeal or close the appeal also.
Yes.
Close the writ also.
Even on the last occasion, lordship, the impugned order, because there is a direction to the petitioner to modify the contents of the writ petition, because the pleaded facts were not there. In absence of the pleaded facts, lordship, the interim prayer was made.
My lord, honorable single judge asked for his
That has
appointment
not been
letter,
done for last 3
which was
months.
not under challenge. Then, my lord, after 15 long years, honorable court wants my appointment letter. Where do I go?
Take that. The challenge in this appeal is to the order dated 19/6/2025, passed by a learned single judge in IA number so and so, arising out of WPC number so and so, whereby the prayer of the applicant / petitioner for staying the recruitment process has been rejected. Stop. The records reveal that the appellant had approached the court by writ petition C number 43878 of 2024, challenging the decision of the authorities to question his appointment, which was in the year 2010, on grounds of shortage of requisite experience for him to have been appointed as associate professor in the associate professor where?
NIT
Silchar.
Associate professor in NIT Silchar. In the meantime, the new recruitment process for the post of professor in many streams was advertised. Since otherwise the appellant / applicant could not have applied against such advertisement for recruitment, he had sought stay of the entire process, which has been rejected. In all fitness of things, we deem it appropriate, with the consent of the parties, that this appeal be heard along with writ petition WPC number 4378 of 2024. Let this appeal be listed along with the WPC number so and so on give a date. After 2 weeks,
Good.
now your grievance would be over.
For the
We would
timing,
hear
Lord,
your writ petition
for the
also.
timing, recruitment result may not be announced.
What?
This recruitment is already finished.
No. This is only to allay your grievance that your case has not been taken up till now. Otherwise, we are inclined to reject your appeal straight away. But we will hear your writ petition, we'll see, because those facts do not find mention in the order. Right?
Right.
So with your consent, we are hearing the writ petition as well.
No, what about my appeal? I mean, whether my appeal has been, my lord.
No order has been passed in appeal.
Right.
The order stands. There is no stay of the recruitment process.
Right.
Whether you want it or not, we can deal with your appeal. Whether you want your writ petition also to be heard by us.
Yeah, my lord. There is no doubt about that.
All.
For the timing for 15 days, they should wait for announcing the result.
The hands of the clock can be turned back. Don't worry about that.
My lord. Grateful, my lord.
17 September. Item 11.
In this case, I am appearing on behalf of respondent number 3 and 4. I want 3 more week time to my lord file affidavit in reply because he has served copy day before yesterday only, my lord.
My lord, if your lordship permits me, on the first occasion when the matter was listed, the copy was given, but for further additional copy was given day before yesterday. That's I agree. But the problem is there, 2 things. The inquiry proceeding which was being initiated
That's
against.
for the merits, Mr. Burgoyne. That's for the merits. Now, can you have the patience of waiting for the counter affidavit in the matter? They are supposed to answer.
My lord.
See, Mr. Mahanta, you will be required to answer 2 things.
My lord.
There was a proceeding was contemplated against the officer.
My lord.
But instead of serving him the charge sheet, you decided his fate under section 20 of the Nagaland Services.
My lord.
My lord.
Right, for compulsory retirement, deadwood, public interest.
My lord.
Now, what was the material before you?
Material, my lord, there is several material because.
So therefore, you'll have to say,
my lord.
have you taken a holistic view of the matter?
My lord.
So you will have to say that in the affidavit.
Yes, my lord. I want to
let
place
that
on
affidavit
record before this honorable court, my lord. All everything because my lord, you're so shocking, my lord. Your lordship will, my lord, even in one word, my lord. Your lordship kindly see, my lord, in morning, my lord.
Mr. Mahanta. Mr. Mahanta,
my lord,
we are not on any shocking incident. There has to, I mean, this kind of order cannot be passed on a solitary instance.
My lord.
You understand that?
My lord.
Because no departmental proceeding, he is considered to be a deadwood.
Deadwood.
He has shown the door. Now, it cannot be questioned otherwise on other grounds because it is no stigma.
Yes, but it's a condition of service.
Condition of service. But then there has to be something on record.
Yes, something on record. That's why I want to place it before you. On by way of record. My lord, by way of affidavit.
See, all such orders are to be tested on the anvil of the considerations which have been laid down in
Vaikunthana's case.
Yes,
and Colonel Jain Sinha. These are locus classicus.
Right.
You know, these days, this provision is being invoked, but then there has to be something more to it.
Yes.
Lord, I must update, your lordship permits me, then I would like to bring one fact more, if your lordship permits me.
Wait for the counter affidavit, Mr. Burgoyne. You seem to be in great hurry. We are not in a hurry. You have already been shown the door.
My lord, I have not been paid a single money even from the day of my suspension, my lord.
Cannot be, no?
4th December, I was put under suspension. My substantial allowances have not been paid.
That is something different.
I made my representation.
Just a minute, Mr. Burgoyne. Before taking that decision, the authority would have revoked your suspension. Otherwise, this order could not have been passed. Why do you have to say something which is beyond records? His suspension would have been revoked.
Yes,
I will wait for his affidavit.
Decision would have been taken. We don't require to go through the file to say you this.
My lord.
Mr. T.J. Mahanta, learned senior advocate. For response number?
3 and 4.
3 and 4. Seek some more time to put in his response to the petition. let the affidavit on behalf of respondents number 3 and 4 be filed positively by the next date. Read with a copy in advance to the council for the petition. Re-notify on after 3 weeks.
22nd September.
Oblige.
Item 13 to 15.
Yes.
My lord, I express my apologies.
Why are you so apologetic in the beginning? Why?
Because last time also, my lord, I had to take an adjournment in this matter. On
Today
behalf of-
also you wish to take adjournment.
Yes, my lord, because one of our colleagues' mother had expired, my lord, which is why learned additional AG had to be out.
Look at this. You are Mr. Roy,
Bothaku, I Bothaku.
Mr. Borthakur, who appears for the petitioner.
I mean, item number 14, my lord.
No, this is which matter? Item number 12, no?
13, 14, and 15.
12.
12 adjourn.
12 has been adjourned. Okay, all right. Yes,
I mean,
he
14.
wants an adjournment.
Yes, my lord.
Any objection?
It's a personal.
That's right.
Otherwise, the bar
This
will
is
become-
expected. This is expected of the senior members of the bar. You must accommodate persons.
Yes,
Of course,
that's true.
any delaying tactics is not
No.
acceptable. But there is some personal difficulty of this young man. Why not? Take care. As prayed for. Which is the next date that's available to us?
October.
This will have to go in on the month of October.
Not in September, Mila.
September, we are absolutely full.
And it's 14th, my lord, in 14th of October.
No, October, we can do it even before. October, we'll list on calendar.
Reopening the
13th is reopening. Yeah, we can have it on 14th.
Deeply obliged.
Again, prayer for adjournment has been made on behalf of the respondent, but consented to by the appellants. List this matter on 14th of October.
Deeply obliged.
These matters on 14th of October.
Supplementary list for hearing, item 17.
We will come back after 5 minutes. Yes.
May it please your lordships. My lord, in the writ appeal, we are sealing the judgment passed by the Honorable Single Judge on 15th of July 2024, which is at page 203.
Yes.
But before that, with my lord's permission, may I give a backdrop of what actually happened?
Please.
My lord, there are two board of directors of a particular cooperative society. The first one is the erstwhile, and the second one is the present one, which is before my lords in the writ appeal. The erstwhile board had a requirement in law, specifically section 39 of the Act, which mandates that a board must hold an annual general meeting within first 6 months of the cooperative year. In substance, 1st of April to 30th of September, you hold an AGM, regardless of the fact of whether it fructifies or whatever happens, whether it's an AGM in general or dealing with elections. Accordingly, during the tenure of the first board, the earlier board, which is 25th of May 2017 to 25th of May 2022.
This was for 5 years.
Absolutely. The earlier board in Bath,
Yes.
they held an AGM following the process of law. That was sometime in
on 30th of September 2021. Now, this AGM was not concerning election. This AGM was concerning the budget, the insurance of the farmers, the staff employments, etc., milk supply, other ancillary things, but it was an AGM to fulfill the mandate of Section 39. Now, once the proceedings were approved on 9th of October 2021,
30th of September.
that was the AGM was held.
Yes, and then there are.
The approval was granted by the jurisdictional authorities on 19th of October 21. Then the secretary, my colleagues, my senior colleagues, client, the fourth respondent herein, took it up as a complaint or appeal before the authorities that it is bad in law.
No, secretary did what?
Secretary challenged this approval.
The approval.
The approval, which my lord finds at page.
Approval of the resolution of the AGM.
Absolutely. Page 125 is the appeal by the secretary without taking my lords there.
Secretary appealed before which authority?
Before the registrar. The assistant registrar of cooperative societies, my lord, Karimganj. Now, in substance, what the secretary had alleged was that although in time it ought to have been held within 30th of September 2021, but actually the meeting was held on 3rd of October. And though the notices were issued, somehow or the other, it was projected to be within time, although it was beyond time. And if it was beyond time, the board had to be dissolved and the directors had to vacate their office. That was the count on which the assignment was made. A parallel thing was also drawn that he was entitled to some money, 366 odd or 9 lakhs odd, some 12, 15 lakhs he would get from authorities, which also he required to be compensated. These two things were there. Now, during the pendency of this appeal, which was on the count of Section 39, non-compliance, and his payments, the pendency without, the board of directors, the erstwhile, convened an AGM by following the procedure of law, this time for the election.
This was when?
This one was held on 17th of April 2022, within their tenure. The law mandates, my lord, with all respect, that they must hold it within their time so that the new body takes up forthwith. Possible.
Yeah.
So once the AGM was held on 17th of April 2022, on 25th of April, the secretary again submitted a complaint actually, which can be termed as an appeal before the jurisdictional authorities, which my lord finds at page 131.
No, this time the authority was again assistant registrar.
This one was the registrar. Registrar. Now this appeal was on 2 counts. How we just migrate to the grounds on which it was challenged. I trust I'm being able to persuade.
You're going forward very methodically. Yes.
Lordship. This was on 2 counts. The first one was that non-compliance of Section 39. Therefore, the board had to be dissolved, and therefore it was reiterating rather the challenge in the earlier.
So therefore, this election was nothing.
No, this election, they said, you prepared the fake voters list, etc., and consequently it hit upon this election. These were 2 counts. Now, I'll address on this later. Well, narration of facts I'm just going through. Now, so far as this was done, during the pendency of the appeal was approved. I mean, the AGM was approved, the election was approved. Approval date, my lord, is 4th of August 2022. As against this, there was a review at page 82.
Review before which authority?
My lord, the same authority. The registrar.
Until this time, both the complaints,
Yes,
remain pending.
No, the second one was disposed of.
Second one was dismissed or disposed of?
Dismissed. Dismissed, so it came for review. dismissed on 4th of August 22, and the review was filed on 12th of August 22. In the review, he abandoned one cause of action or limb of assailment. He confined himself to section 39, non-compliance. And so far as the election held on 17/4/22, whereby the B board was formed, that was not taken up in review, page 82. Rather, he also prayed that he be brought back in service because in the meantime, on 10th of February 2022, the earlier board had removed him. So his status was ex-secretary all this time. At this point, since the review was not being disposed of, he approached the Honorable Court, and the Honorable Court was pleased to direct by 5th of September 22 in order that jurisdictional registrar to consider and dispose the review. The matter went to the jurisdictional registrar. At this point of time, the review was allowed. The review was allowed, that is at page 89. It would have some bearing, if I may invite my lord's attention to page 89 for a moment. Or I can just roughly show down. While recording the antecedent facts, the reviewing authority recorded that the proceedings were in fact held on 30/9/2021 as the officer who was there, ARCS as Assistant Registrar of Cooperative Societies Karimganj, had so affirmed. But on the count of tampering of records, it was concluded that since we say the secretary had held it and he says, no, you were there, the jurisdictional registrar concluded that no, since the chairman had last signed and the jurisdictional authority cannot say who brought it, therefore the last signatory would have to be held to be guilty. Accordingly, the order passed was the proceedings which were approved of Board A were rejected.
So therefore, this board also was disbanded.
Herein comes the legal fiction, my lord. When the earlier board held an AGM within the presence of section 39 and did not hold the election by that meeting, it was on the budget, insurance, etc.
Follow that, yes.
Their holding is what is within the four corners of 39. Even if the approval is gone, rightly or wrongly, it does not essentially say that the board dissolves. Meeting was held. In the meeting, they alleged of tampering. His count of that statutory date was not maintained, was not even discussed, not even pleaded. I mean, urged before the reviewing authority. The basic count was, you have crossed the 6 months time, 39 is strict, board must dissolve. That was not addressed. Rather, the reverse happened. The reviewing authority took it at page 90, that the ARCS who was there, he says, no, it was held on 30th of September, within time. But on the count of tampering, so the chairman had signed, therefore, the approval to that meeting was declined, cancelled. Even if I take it for a moment, my lord, that this, rightly or wrongly, that approval goes, the board cannot be held to be dissolved within 39 because the meeting was held. The board would be dissolved on the count of section 39 non-compliance, and that was not even discussed in the review order. When the matter was taken by us before the Honorable Single Judge, this was also taken. But I must say, with all humility, I'm not blame gaming though, it was different counsel who would argue the matter. It was taken up that review did not lie, the grounds of review were not there, and the entire discussion went to that line. And the Honorable Single Judge was pleased to hold that since, and there was an order of the Honorable High Court directing the jurisdictional registrar to take up the review, so there was nothing wrong with it. But having said so, our election was set aside. There was no challenge to it. What I'm trying to persuade my lord is that, so far as the earlier board is concerned, earlier board held two meetings. The first one was to protect them from section 39, which was not an election. Even if that goes, that can be regularized now. We can do it, even if that goes. But so far as our meeting is concerned, our election is concerned, it's not under challenge. And even on the touchstone of section 39, even if I say, with all fairness, my lord, that the earlier board should go, that was not even discussed by the reviewing authority. Trust I could Please the matter.
No, tell me one thing.
My lord,
Now, the first board,
my lord.
the life of the board was 25/5/2017 to 25/5/2022.
Lordship,
Following the provisions mandate under 39
My
of
lord.
the Cooperative Societies Act,
Lordship,
AGM was held, not relating to elections, but
My lord.
relating to budget and other things.
absolutely.
So this was 39/2021.
My lord.
This was approved on 3rd of October, correct?
This was approved on 9th of October.
This was held on 3rd of October. That was the claim, approved on 9th of October.
Held on 30th of
19th
September.
19th of October.
Held on 30th of September, approved of 9th of October. In the challenge, they projected 3rd of October.
So this, this was challenged.
Challenged.
And when was the election held?
Election was held on 17/4/2022.
17 by the AGM, 17/4/2002.
My lord,
When this was challenged under, before the assistant registrar,
my lord.
first challenge. by
First
the
challenge, my
secretary.
lord.
So this remained pending.
This was dismissed
This was dismissed.
by an order at 134, which says that you were holding the books, everything, so temperament goes in your way.
Yes.
But nowhere the count of whether within time or beyond time
Okay.
was discussed. And even in review,
All right. Thereafter, the AGM and elections were held on 17/4/2020.
my lordships,
This was approved on 4/8/2020.
my lord.
But when was the filed?
No, this was approved on 2/5/2022
approved on 2/5/2020.
and 4th of August 2022, the appeal was dismissed.
Which appeal?
The second appeal which they had filed after the 17/4/2022 AGM was held,
Okay, appeal was dismissed on 4/8/2020.
my lord.
And then they filed a review.
Then they filed a review
Hmm.
on 12th of August 2022. Here, they abandoned the tangential challenge, if maybe, to my election. Here, they only go on 39 aspect, whether within time or beyond time.
So this was the first one. The challenge therefore was with respect to the first challenge. which they had.
Absolutely. In review, they go back to the first one. I'm so grateful. That's what. Could not have. And therefore, my AGM,
And why that review was entertained?
my lordships,
Because there was a direction of this court.
absolutely. But in all fairness, before the honorable single judge, whatever arguments I'm trying to make, this was not the context. The context was whether the jurisdiction of review was there or not, a procedural review. That was there. I was not on that. I'm not on that.
So that doesn't concern us now
My
because your election has been annulled.
Yes, that was. And to the extent, if I may say, with all humility, my lord, that even if the first one rejection is held to be correct, we'll rectify it now, the present board. AGM was held not for election,
That's something different, Mr. Bunning.
my lord.
That's what you will do. First, you have to, your
Be in power.
election has to be salvaged, no?
My lordships,
You will do whatever you will do, that's something else.
lordships.
Now, therefore, we are at the moment on the decision of the letter single judge that on this ground, ultimately the review was allowed.
Our election would go in the factual premise only on one count. That the first AGM which was held in September 21 was not held on September 21, but on October 21. If that is brought on record by an order of the jurisdictional authority, then certainly the board was not there and the registrar would depute a one-man committee to hold the election. Then the election would go. To that extent, I would also concede, my lord. But that was never considered. That limb was never discussed.
And that was dismissed.
Yes, and that was the crux of the issue. If that goes on the count of September, then my election would go certainly when I bow down to that.
Then everything is
Everything is gone. But that was not even discussed, my lord.
And the second review was absolutely different.
Different?
This review could not have gone back to,
My lord,
that's your argument.
that's what I think. I rest my case, please.
Yes. Yes.
So, my lord, there is a mandatory provision is there. Every cooperative society in a year.
See section 39 of.
Yes, my lord, section 39 may kindly be seen.
Yes. So my lord, by this provision of section 39, every cooperative society in a year has,
We have understood.
yes,
You don't need to repeat the.
yeah, yes, my lord. So the society is to hold the
That's
AGM.
right. So they claim that the AGM was held on 39,
No, it
2021.
was not held. Manipulation was there.
That was your challenge. You say that it was held on 3rd of October.
Yes,
And this was the complaint made by you.
yes,
And complaint was before the assistant registrar, which got dismissed.
yes,
So therefore that chapter is closed.
yes, close.
And then thereafter, if that chapter is closed, then the life of the first board remains.
Yes, remain.
Technically,
Yes,
you
remain.
forget about
Yeah, my appeal is dismissed with this remain.
your appeal is dismissed.
Appeal
You
is dismissed, body is there.
you never challenged that decision of the assistant registrar.
No, no. The
When
decision
your,
has
when your complaint was dismissed,
the complaint was not entertained. Then I filed appeal before the registrar, highest authority.
yes,
Appeal was dismissed.
okay, that's same thing. Appeal was
Same
dismissed.
thing
All right,
come, same
all
thing come.
right.
Then immediately I filed review.
Hmm.
There actually.
No, you filed review about something else.
No. Against, for review of the order of the appeal.
Okay.
I filed review.
Hmm.
To that registrar has dismissed my appeal.
Hmm.
So I have review,
Hmm.
filed review petition, then review of the order of the appeal.
Hmm.
Then while reviewing the order of the appeal, the registrar has also heard them also.
Hmm.
He has heard them also, that why there is a manipulation
Hmm.
of date 13/9/2021.
Let us see the order passed in.
Yes,
review.
ma'am. Yes.
Page.
Yes. That your lordship will find page. No, page 89. 89.
Review.
Review. Page 89. May I read one?
Decision. Mr. Panik,
My lord.
where have you questioned this reasoning of the reviewing authority? Look at this. Now come to page 90.
19.
90.
Nice. My lord.
Third paragraph.
My lord. May I read?
Yes.
The ARCS was asked to ascertain
as to who had submitted the proceedings of the AGM,
In the office of ARCS.
ARCS, but the ARCS were unable to ascertain the same, and hence the responsibility of tampering the document rests on the person who had last signed the proceedings of the AGM. If
Now, where have we, this logic is spurious.
even if the writ petition was filed, assailing the entire order, even if I'm taking the argument to the extreme,
No.
even if it is accepted,
Okay,
to
then.
the extreme, the other one, even if it is accepted, then also within the language of section 39, the fact that this meeting was held on 39 is paragraph just beyond. The ARC stated that adjourned AGM was held on 39/2021. It is the holding of the meeting, not the approval to the resolutions drawn. May I invite my lord's attention to?
No. See, if it is 39, if it is, the ARCS Karimganj stated that the adjourned AGM was held on 39/2021, that's the statement.
If a jurisdictional authority is stating and the reviewing authority is taking it, but on the count of tampering the authority is directed. Directionally, it goes that way. It does not go to holding or not holding within 39 or not.
No,
Rather,
that
it's accepted.
That argument.
No,
is
what
not
I'm
very
on.
solid.
If there would be a finding that it was not held within 39, then the board would dissolve. But if on technical aspect,
Mr. Manik, you can't take that argument too further. I mean, too farther.
my lord,
You can't take that argument too farther. See, that the meeting was held, if the whole idea was that it was not held on 39/2021, rather on 3rd of October
My lord.
2021,
my lord,
then you lose out.
the earlier board goes. I also follow.
The earlier board goes.
Yes.
Now, this was ascertained. I mean, the challenge was that every record has been tampered with.
Or let us say records were tampered.
Tampered. So therefore, was this the index on which it could have been decided? Who last signed?
No.
So that is the question that
That
you
is
have
the
to
question.
argue.
Absolutely.
And don't take that stand that even if it is done, the meeting was held. No,
My lord.
then everything goes.
And everything goes.
That argument, the alternative argument that
My
you
lord.
had taken,
My
the argument that you had just advanced,
My lord.
that assuming that this is correct,
My lord.
but a meeting was held on 39/2021. No, you can't say that. The meeting was not held on 39/2021. That's his allegation.
And that was not decided.
So therefore, why do you go to that extent? You
What?
say whether the decision of the authority, the
Oh.
registrar,
My lord.
on this index that it was last signed. See, the argument
My-
which you need to advance is that it was in the custodial ledgers of the secretary.
Secretary.
And therefore, this assumption is wrong.
Lordship.
ये बहस नहीं करके आप दूसरी बहस कर रहे हैं.
My lord.
You're
That-
making a different argument, making it unnecessarily look lengthy.
So far as paragraph 13 onwards, the writ petition at page 31, the statements, my lord.
Forget about your contents. We are looking at the order now.
Right.
So this was challenged.
This was challenged.
What happened? In this challenge, what?
In this challenge, honorable single judge, my lord,
The same, impugned order.
impugned order. Now we come to the impugned order. It
Where
starts
has
at
it
page 203. It starts at page 203.
No, give us the paragraph.
My lordship. Page 214, paragraph 31. Here, my lord was pleased to proceed on the powers of review. The contention of the learned counsel for the petitioners that the exercise of power of review was not proper, if accepted, would amount to entertaining a collateral and or veiled challenge to the order dated 5/9/2022 passed by this court in WPC 5805 of 2022, which has otherwise attained finality. The petitioners had accepted notice of review and participated in the hearing of the review petition, and this allowed the order of this court dated 5/9/22 to attain finality.
Answer our query.
It was not dealt with by the honorable single judge, my lord, because in the correct sense, it was not even canvassed. The argument was on review. I must be honest, even if it goes against me.
Yes, all right. So, but we are not finding it to be correct, no?
It was not, the argument was not advanced.
This argument isn't correct.
The different argument was advancement.
Internally, let us see this. And this here, I don't know what here. The review could chale. Just went on that. That is not, that's not whether the reviewing authority correctly decided it. Entertaining a petition is one thing, but whether this could have been the ground. This cannot be the ground now. Suppose last order last order is signed by me. You sign an order, I sign an order. And then it goes before the court master to upload it. And if there is a temporary, they would not blame it me. Forget about my position. They don't blame it on me. It's with him. And then evidence had to be adduced. No, last sign, that's right. The date is, they say it is 39/2021. It is that case.
Your lordship,
The complaint is that it is on 3rd of October, but this is an oral complaint. And what is the
record
basis?
is there, man. Proceeding is there, last sign proceeding is there. Your lordship may examine also that one also. Now, who has last sign?
Do we have signed?
He has
No,
signed.
assuming, we are on a different ground, Mr.
Yes,
Sinha, together.
of course, man.
Assuming that Mr. Banik has signed it,
Yes,
assuming,
yes, man.
then can that be an indicator to decide that he has tampered it? Where is the evidence of tampering?
Because
So therefore, the reviewing authority, the registrar, believed your statement, just like that.
no, no, my lord, because the proceeding were produced before he. He is the
Do we
fact
find it
finding
in
body.
the order? No, we.
Registrar is the fact finding body, my lord. Registrar, yes.
Where is the discussion on fact? The only logic employed, Mr.
Because
Sinha, try and understand this.
Yes, yes, I have come to know
The
that.
only logic employed by the registrar is that this has been signed, the allegation is of tampering, therefore he must have tampered. Can this be the logic?
My lord, because yeah, that adjournment meeting, it was 13/9/2021 was the adjournment meeting, my lord. And your lordship, the notice was issued for holding this AGM. The law is there. On the next week, same day, whether
Where is that discussed?
not discussion is not the law is that, my lord.
No.
Now that
What is the law?
record says, yes, my lord, the record
What is
says,
the record? Let us see the record.
yes, my lord.
Where
Yes, page 62. Page 62 is the record. There's a temporary.
The registrar shall give the approval if no approval is petition. So आपने से बना ली अभी but 19 because
from 1910 it was approved. This was challenged, huh? Take it to challenge. Now let us see the record.
Yes, sir. Page 60, my lord.
Page
60. And vernacular, you'll also find the last part, page 73. Page 73. Vernacular, where the resolution was ended.
Then let us see page 60 first.
Yes,
Is that the
60.
record?
60 is the type copy, my lord. He has typed so shortly, my lord, nothing has been mentioned. Page 60 is the type copy of that entire proceeding.
Which page that you want us to see?
Yes, that is page 73.
73.
73. The meeting was ended by adopting the resolution there. In the first paragraph, there is a overwriting. It was 3/10/2021, but it was overwriting as 39. That is, my lord, the signature of the secretary. And their signature in the chairman side, there is no signature. And out of after that, the chairman has written by himself. They extended the additional things he has been added. Chairman, then last, your local chairman, 13/9/2025.
Now this signature is of the chairman.
Chairman. So he's the last person keeping the.
Last person nahi hai. Now tempering, Mr. Banik, the tempering would not have been done by him because otherwise he would have allowed it to be 310.
My lord, so far as page 135
He
is
would have
concerned.
allowed it to be 310.
I understand. The same, that's fairness. In page 135, the same authority while discussing the appeal, the reviewing authority while discussing the appeal had held otherwise. On the same documents, may I invite my lord's attention for a moment? The appellate order,
But
page 135.
appellate order has been reviewed, no?
No, the same authority, what he saw from the evidence, that one.
What we are seeing from here.
Correct. What
His perception and our perception would be different.
True. What
Let
I'm
us-
on,
Let us see that page.
135. 135. Well, I'm trying to persuade you.
135, yes,
135, the second paragraph, if I may read, Miller.
yes.
After perusal of the records and hearing all concerned, it is observed that the AGM meeting held on 22/9/21 had to be adjourned due to lack of quorum. The adjourned meeting was held on 30/9/2021, in which quorum was achieved. Subsequently, the Assistant Registrar of Cooperative Societies, Karimganj, approved the proceedings of the annual general meeting. It also appears that it is only the ex-secretary, Shrimati Dalde, my friend's primary.
This is not an application of mine. Again, I mean, we had not seen this record.
Who had held it, the appellate in the
Therefore, the
who could have
argument
manipulated?
Who could have done with it?
Man, because he was holding the original. That was the view taken by the authority in appeal, changed in review. Why is absent? A different version comes up in review without giving the filling up the gap.
Now,
That's my case.
More was required. This means nothing. This means nothing.
now that's
Who did it? In version of the same authority, it was a secretary who, I'm not in the factual part now, but I'm on, this discussions ought to have been
That's
this.
all right. We would have, in fact, it was us only, we suggested you this argument. But then now looking at this
My
tampering,
Lordship.
on a plain look at the document, it appears to be that something has been done.
310 would be 39.
3 has been made 30 and 10 has been made 9. Now, assuming that you were the last one to sign and that
Lordship.
is not the ground.
Lordship,
But then if he would have tempered it,
my lord.
he would have allowed it to remain 310.
There is another version to it, which is of course on assumptions, but if lordship permits, I may just get it. Since as per the appellate authority, he was the custodian of the record, so he could have inserted it and then taken to be incorrect, the date would have been put in so that the argument can be built.
That is a big argument.
No, I am not on that, but all
Where
these
have you
things,
countersigned it?
but somewhere,
Where have you countersigned it?
Why
Suppose
not?
you had countersigned it. Suppose whenever you make corrections in the date, suppose
No,
I
that was-
sign a date,
that was,
I immediately countersign.
the entire thing was the secretary had tampered, that was what the projection was.
So
made.
secretary would have tampered, he would not have, by tampering, he would not have,
I squarely for.
he would not have given
Yes,
a
yes.
date which would have been beneficial for you.
But if a man thinks a little bit smarter to it, he would have done it this way.
You're
If could have been, but I'm not
you're
on that.
imputing more intelligence to him than what he has.
But notwithstanding that, he was only on the insurance budget, etc., and the meeting was held. It is the holding of the meeting and non-holding of the meeting which gives rise to the consequences spelled out as mandated in section 39. It is not on the correctness or the fructification what it ends up with. The approval may be granted, may not be granted. Tampering may be done, may not be done. But once the meeting is held within the time, it's held within the time. And it's not held in a manner,
Just a minute.
my lordships.
The meeting would be held, a non-porate meeting is no meeting. A non-porate meeting is no meeting in the eyes of.
no meeting.
There is
Unless you shows the law.
there is one judgment, if I recall correctly, Jaharuddin, if I believe correct, that if a meeting is held in context of Assam, my lord, if a meeting is held, procedure is followed, but that not correctly ended or so, then 39 would not apply.
Where is
Something-
that judgment shows?
I can read it, Kuman. I would have to get back to that. I do not have it, but I do not think that question would come up with us.
See, therefore, that question will come up now for the reason that would be a separate strand of argument. Look at this now.
Watch it.
Now, the learned single judge was testing the order passed in review. Correct?
My
So this review order applies a logic which is not acceptable on face of it.
my lord.
But then if we look at the records, then it appears that even if it is not assumed or presumed that you were the last one to sign and therefore you have tampered, this looks as if it has been tampered. And this the secretary would not have done. That's a plain logic.
I leave it to your lordship. That too, I cannot further say anything more.
Unless you say that the meeting of 22/9/2021, that is not in dispute. Therefore, if that meeting was held, whether resolution was passed or not, it remained non-corate meeting. because of lack of quorum. Lack of quorum is called non-quorate.
The holding on 22-9, he starts up with his, I mean, it's a pleaded stand. No, it is pleaded that the 4-9 notice which was required for that, he had issued. But the chairman has held it back and proceeded wrongly. Subsequently, it was shown that in terms of 4-9, the 39 meeting was held. That's the pleaded stand. That it started off correctly, but ended up differently.
Annual general meeting held on 22/9/2021 is not being disputed by him.
Lordship.
It is not being disputed by him.
My lord.
And if you can show from the law that
Proceedings adjourned.
22/9/2021 was the meeting, and therefore this meeting would make up for the requirement or mandate under 39.
This,
then perhaps you are saved again.
yes. It says, the law says if the meeting is adjourned, 7 days, same time, again the meeting has to be
Same,
held.
there is the answer.
I'll come to
There is the answer he's giving.
Absolutely.
The meeting was adjourned on Wednesday, but the
where is
next
that
meeting
rule
was held on
that
Thursday.
Where is that rule which says?
Yes, 34-2. 34-2. Next meeting was held on Thursday, not Wednesday.
The forum for a meeting with the family shall be discussed.
Ordinarily.
Thirty-four-two. 34-2.
Yeah, 34-2.
Read that.
Yes, ma'am. If within 1 hour from the time fixed for the meeting of General Assembly, a quorum is not present, the meeting shall be stand adjourned ordinarily to the same day in the next week at the same time and place.
So next week would be?
Next week will be Wednesday.
No, date.
Yeah, date will be on 29. If it is on 20, if it is notice is quorum was held, sorry, meeting was held on 22. So here also, Mala, we can catch hold this one, but that the the proceeding which they made 39.
Perhaps not ordinary.
Yes, but the chairman of the meeting may, however, decide to adjourn the meeting to a later date, not later than 15.
Yes.
So
There
there
is
has to be
no-
some record.
There is no record that he has taken some more time that.
No, it was not held on 20.
Here it is, no, here it is said in the order which he has just read now, that quorum was not fulfilled on 22/9/21. Next week meeting should have to be held on Wednesday. And now in the vernacular also you will also find that meeting held on Sunday, 39. But they have made it a Brihaspatibar. It's apparently, but who has done that is
But what is this vernacular thing? What does it read?
Yes.
Can you just explain to us in English?
Yes. That quorum which was not fulfilled on 22/9/2021. That was, the day was on Wednesday. The law says on the next,
I'm not talking about law that you have said.
yes, so
So what
next week on the same day,
No,
meeting was to be held on Wednesday, not Thursday.
You have followed that.
Oh, vernacular said that it was Ravivar, but meeting was held on Brihaspatibar. Yes, Malab, the record says. They could not correct this one, my lord, the vernacular one. Notice your lordship will find. Page 61. Page 61, the English which they have made, the vernacular was, your lordship will find. Bela 11 ghotika. Doinik, then it is Ravivar or what, there's no date. No, date is there, but there is, this is not Budbar. This is Ravivar. Ravivar was just the Sunday. The irregularities is there. So, my lord, I being a secretary, I made a complaint. Complaint was not entertained by the Assistant Registrar of Cooperative Society. Then I filed an appeal before the registrar. Registrar simply he take is that since the records remain with the secretary, so he has opined that finding, my lord. He has arrived at that finding. So I filed an again review. Then no, in the proceeding there was an addition. Last man signed was the chairman. That the registrar, my lord, arrived at finding that no last man, something is different. That's why, my lord, he has in the review, he has reviewed the order of the appeal.
Just a minute, let us see the order, let's see the appellate order, page number.
Appellate order, my lord, finds at page 134.
And where is the order in review?
Review order, my lord, finds at page 89.
April of the one. Calendar.
All right, but then once it is reading on that dispute, we need to speak of it. Even yet. That decision not taken that it cannot be decided here. We could have rejected it saying that it's a dispute question of fact and they are not tribunal. So there is no provision against the appeal. So we can speak, once the court is speaking accordingly, to see whether the reasoning is done. Reasoning is done.
I believe, my lord, for that.
That's the special.
Wait a minute.
Okay.
Not with the logic, what says.
You want.
If this is a wrong. Which means accepting this is a real. This is not. This is not. Whatever he did, this point of review teaching file be taken up the page and this point of by public speaking order. So that's how. So he says that this review. We are not on that.
If I'm permitted, just one liner.
Mr. Manik, you're in deep trouble now.
May I just wriggle out of the trouble for a moment, at least attempt to?
Yes.
So far as my colleague is referring to a document saying Sunday whatsoever, admittedly, I use with all responsibility the word admittedly, it is a document signed by him and the mistake of Sunday, Wednesday whatsoever is by him. Now, why I say so? Page 125, his appeal.
Can we look into that?
My lord.
Has the single judge looked into that?
No.
He has not looked into that.
Because in all fairness, the argument advanced by us was on review. We also did not take it. I have
In
to take
fact, the learned single judge should have said that these are matters of.
My lordship.
These are disputed questions of fact. Let you go before the civil court to decide.
The
That would have been
registrar,
the best.
no, the registrar, my lord, with all humility, can still decide this. Can still decide within a time frame. Don't take a presumption in his favor or my favor. Ascertain at least what my lord's view was that yes, if you have done it, let it come in the form of an order from the judicial authority who can inspect the records and get back to that. Even the appeal can be kept pending for that.
Because these are disputed questions of fact. The single judge ought not to have gone. Ought not to have. Tempering practice. We are not experts. They can go with the registrar. Yes, are you agreeable to it?
Which one, man?
Now,
To examine the matter again.
put it to you.
To examine the matter again by the
registrar.
fact-finding body, my lord.
We can't, the single judge could not have decided it. We can't decide it.
Yeah, my lord.
We can't reduce ourselves or upgrade ourselves to handwriting.
Or my lord, to remand back to the single judge again for to re-examine
No.
it. Or the
Single
fact-finding body, that registrar.
Correct approach of single judge would have been to
Register.
send the parties to appropriate forum would have.
I agree with that. If the registrar may examine again with all records, but whatever my removal, because I was the secretary during that time.
The earlier board
My
removed him, not us.
removal has come later.
We will not restore your appointment. You participate and then it will be a second cause of action then.
Now, because my removal was after that, after 30th, when I have made complaints of that, the body has removed.
We are not restoring that. You have not asked for any other. Single just, does single just say that your appointment is restored?
No, that is register at says, my lord, register say. Register already say. Register has say. Because that was not under challenge. Register has say.
That question will be decided. If it is found that it is tempered, then perhaps he can, whatever. Otherwise, also the period is over. Elections have to be held.
No, election has to be by as per 41(6), my lord. One man committee will hold the election, but they are not the body.
They're not.
They cannot be divided in the body, my lord. And that body, my lord, registered say, my lord.
Therefore, this
So-
decision, just a minute, Mr. Sinha.
Yes.
This decision also would be left open for the registrar to decide. Take down.
I'm grateful, Miller.
That, my lord, that's one thing. My appointment, the removal also may be decided by the registrar. My lord.
That's what we said, no?
Yes, my lord.
That's what we said.
And time limit may be given, my lord, to the registrar. Otherwise, it will matter for 1 year, 2 years, my lord.
We have heard Sri, he's I Banik.
Yes.
Your IS Banik.
No, I'm just S. Shubhajit.
Yeah. We have heard Sri S. Banik, learned counsel for the appellant, and Mr. B. Sinha, correspond number?
4.
Correspond,
4, my lord.
correspond number 4. We have also heard SK Talukdar for correspondence number 1, 2, and 3. By the impugned judgment dated so and so, passed in WPC number so and so, a learned single judge of this court has held that the appellant board gets dissolved for not complying with the provisions of section 39 of the Assam Cooperative Societies Act 2007. As a result of this, even the next elections held on 17/4/2022 and approved on 25th of April 2022 is rendered non-est in the eyes of law. Short facts which would be necessary for disposal of this case is that the appellant board was constituted for the period 25/5/2017 to 25/5/2022. In accordance with the mandate, in accordance with the mandate of section 39 of the Assam Cooperative Societies Act 2007, annual general meeting was held according to the board on 30/9/2021 with respect to budgetary approvals, etc. Which was approved on 19/10/2021. However, the secretary of the board, bracket respond number 4, made a complaint before the assistant registrar that no meeting was held, no annual general meeting was held within a period of 6 months as mandated under section 39 of the Assam Cooperative Societies Act 2007, bracket hereinafter called the Act of 2007. And therefore, the board gets dissolved. Therefore, the board gets automatically dissolved. However, this complaint preferred by respondent number 4 before the assistant registrar was dismissed.
No, not entertainment.
Was not entertained.
Then I file appeal.
Was not entertained. Respondent number 4 thereafter appealed before the registrar of the cooperative societies, before the assistant registrar, assistant, no,
Registrar.
before the
Registrar.
registrar of the cooperative societies. No, delegate was not entertained. Therefore, where is that order? Page,
Appellate order, my lord.
appellate order.
134.
No, that is after. ETM. Let me come here.
No, that is not required for us. Delegate, they will miss out on unnecessary fact. Okay, what is that?
And therefore, the court gets to stop. This
Before the registrar of cooperative societies, alleging that in fact the AGM was held on 3rd of October, but by tampering of the records, it was made to look like it was held on 30th of September 2021. The registrar of the cooperative societies, on perusal of records and after hearing all the concerned, observe that the AGM was held on 22/9/2021, but the meeting was adjourned because of lack of quorum. The adjourned meeting was held on 30/9/2021, in which there was quorum. Subsequently, the assistant registrar of the cooperative societies, Karimganj, had approved the proceedings of the annual general meeting. With respect to the allegation of respondent number 4, that the date of the meeting was tempered, the learned registrar was of the view that it was the respondent number 4 who was in custody of the records of the proceedings of the board. And therefore, if there was any manipulation or tampering, it was him and not any one of the functionaries of the board. With respect to the removal of respondent number 4 as secretary, no interference was made by the learned registrar. It would be relevant here in this context to state that while all this was going on, elections were held and the present board was constituted, which was also confirmed later. Not losing heart, the respondent number 4 preferred a review against the order passed by the registrar. And when the review was not being taken up, he rushed to this court. WPC number so and so.
763/23.
WPC number 5805 of 2022. And this court, a bench of this court by order dated 5/9/2022. directed that the review filed by respondent number 4 must be taken up in consideration and be disposed of by passing a speaking order. Pursuant to the aforesaid, the review petition was heard and was disposed of by order dated 1st of February 2023. While reviewing the earlier order passed by the registrar, the reviewing authority took note of the fact that the claim of the board was that the AGM was held on 30th of September 2021, which was in accord with the mandate of section 39 of the Act of 2007. However, since there was a challenge to the correctness of the date mentioned in the proceedings, the Assistant Registrar Cooperative Societies was asked to ascertain as to who had submitted the proceedings of the AGM in the office of the Assistant Registrar Cooperative Societies. Somehow or the other, for reasons inexplicable and uncommented by the reviewing authority, the Assistant Registrar of Cooperative Societies was not able to ascertain the aforementioned fact, leading to the presumption by the reviewing authority that since the chairman of the board was the last person to sign the meetings, any tampering or any tampering or manipulation in the records would be presumed to have been done by him and not by any other. Thus, it was held that if the meeting was not held within 6 months, if the AGM was not held within 6 months of the formation of the board, the approval of the AGM, the approval of the AGM became redundant, and the board automatically dissolved. It was further observed by the reviewing authority that the board of the society is to be constituted afresh as per the mandate of section 41(6) of the Act of 2007. This was challenged by the board. I think these facts are good enough. This was challenged by the board before the learned single judge on several grounds. Including that the logic employed by the reviewing authority for holding the board to have manipulated the records to be faulty and untenable. However, it appears that the learned single judge directed his gaze to the very admissibility of the review petition and the powers of the reviewing authority to modify or review the order earlier passed by the same authority. While holding that such order could have been reviewed, especially under the orders of this court, any question pertaining to the admissibility of the review would lead to questioning the correctness of the order passed by the learned single judge asking the reviewing authority to dispose of such review petition without there being any challenge to such order. After having concluded with this issue, the learned single judge went ahead and accepted the findings of the review authority and held that the new board ought to be constituted under the provisions contained in 41(6) of the Act. While challenging the aforementioned decision, while challenging the full judgment of the learned single judge, Mr. Panik has submitted that has submitted with great clarity that the reviewing authority ought not to have decided the matter in this fashion without asking for any evidence to be adduced with respect to tampering. The logic the rationale of the rationale behind the reasoning of the reviewing authority was not acceptable, especially when the appellate authority had categorically accepted the statement of the board that after the meeting was adjourned, after the annual general meeting was adjourned on 22/9/2021, because of lack of quorum, it was held on 30/9/2021, and the resolution of such meeting was finally approved on 19/10/2021.
19.
1910 or 19?
1910 is his challenge. It's approval
On 9/10/2021.
Yeah.
The learned counsel, Mr. Sinha, learned counsel for respond number 4, however, while defending the impugned judgment, has submitted that this logic is not to be seen in isolation or in silos. He has referred to the provision contained in section 34(2) of the Act of 2007, which provides that if within 1 hour from the time fixed for meeting of the General Assembly, a quorum is not present, then the meeting shall be adjourned ordinarily to the same day in the next week at the same time and place. But the chairman of the meeting may, however, decide to adjourn the meeting to a later date, but not later than 15 days, or as may be specified in the bylaws of the society. There is a proviso to the aforementioned rule that if a meeting of the Special General Assembly called on the requisition of the members under subsection 1 of section 34, under subsection 1 of section 33, it shall not be adjourned but dissolved. In that view of the matter, if the statement of the board / appellant is correct that the AGM was first held on 22/9/2021, which remained incorrect, then the next date would have been 29/9/2021 and not later. This coupled with the fact that from a bare look at the records which reflects tampering of the date, justifies the inference of the reviewing authority as also of the learned single judge in the impugned judgment. there is nothing on record, comma, Mr. Sinha contends, which could be demonstrated that the chairman of the board fixed any special date for holding of the general meeting, annual general meeting. Annual general meeting. After having heard the learned counsel for the parties and having perused the records, we have discerned few facts very clearly. The records do reveal that the dates the records reveal that there is overwriting on the dates. Ordinarily, if the claim of the appellant is correct that an incorrect AGM meeting was held on 22/9/2021, then perhaps in all probability, the next date should have been 29/9/2021 and not 30/9/2021, which was not a Sunday which was not because of any Sunday intervening in between. Justifying the next date. Justifying the next date. However, we have also found that the logic employed by both the appellate authority and the reviewing authority for coming to contradictory opinions is not acceptable. The logic that the respondent number 4, the logic employed by the appellate authority that respondent number 4, that the logic employed by the appellate authority that the proceedings book was in the custodial legis of respondent number 4 presupposed that any tampering, if alleged, would have been done by him. Is not without question. Likewise, the reviewing authority deciding that the tampering was done by the board on the sole reason of the last signatory being the chairman of the board is also incorrect. Under this fact scenario, we are primarily of the view that the learned single judge ought not to have entertained this petition because of disputed questions of fact. And it would have been better if the issue would have been relegated to an appropriate forum, or the matter would have been remanded to the registrar for taking a fresh look at the matter and decide after calling for evidence with respect to the allegation of tampering. For the aforementioned reason, we find that the order passed by, for the aforementioned reason, we find that the impugned judgment is required to be interfered with. We order accordingly. We set aside the judgment impugned in the present appeal and remit the matter to the registrar, cooperative societies, to decide it afresh after taking due evidence with respect to tampering of the records and ascertaining the tampering of the records and ascertaining the and ascertaining as to it was done at whose instance or whether there was any tampering at all. The registrar is requested to decide the matter expeditiously, preferably within a period of 6 weeks from the date of production of a copy of this order, from a date of receipt of the production of a copy of this order. For the registrar to decide the issue, comma, he would be required to call upon the parties, comma, ask them to adduce evidence, and then he shall decide the issue by a speaking order within the time stipulated. Within the time stipulated as above. The issue with respect to the correctness of the disengagement of respondent number 4 by the present board,
Earlier board.
by the earlier board, is also
Same.
is by the board, earlier or later, by the board, is also left open for the registrar to decide.